So
you know, I'm just saying, just trying to make the comparison where, like, because you're keeping track of it, but you're not able to pull the data around these young people. But it sounds like maybe we should be moving in a direction where we're having lawyers present. Go ahead.
Yeah, thank you. I can tell you this. A higher percentage of juveniles invoke Miranda or the right to counsel than when you compare it to adults. And so, at least according to the numbers I asked...
Do you have that percentage?
Yes. Oh, I'm sorry. Hold on one second. Okay. Approximately 35% of juveniles, this is just 23, this is just 2023. Approximately 35% of juveniles invoked, whether it be silence or counsel, and approximately 27% of adults, in other words, 18 years or older, invoked. So this is something I flagged because I thought it was interesting that more juveniles actually invoked than adults. So we take these things very seriously. As the chief said, we want the parent, the guardian to be there. We wait hours sometimes for them to show up. And in regards to the other thing you said, why we're not doing that, I can't comment on, there's a state bill pending I can't comment on what its status is or why it's moving or why it's not moving. I don't know.
Okay. Yeah, I mean, even when we're looking at 35% of young people invoking, I'm happy some of them are, but that's still a lot, right? And just understanding that when young people are there, them not invoking to me it doesn't sit well with me in the sense that a young person could be easily intimidated and say what they need to say. I mean, we know this. And so I think even us, as we're moving forward, how are we making sure that young people are protected in this way, and thinking about how we are making sure not only are parents present, but lawyers are present, because even parents can sometimes not understand some of the processes and say some things. And so thank you for your time, and thank you.
Can I just follow up with that too, because one of the challenges I think that has been identified by Councilmember Stevens is the fact that other places like Hawaii, California, Maryland, Washington State, they all prohibit specifically the interrogation of minors without assisting them with a lawyer or somebody that's going to advocate for them. And I'm wondering, would the NYPD support a similar policy in New York?
So ultimately, our position on that is this. We are responsible to many parties in the city. Not only are we responsible to the civil rights as enshrined by the Constitution and all the case law of the suspect, but also to the victim and or the victim's family. So what does that mean, right? What that means is we're trying to be the center of the seesaw that's respecting both sides. And so we feel that's a decision to be best left to the family, for them to make, for the parent to come down, and if they want to invoke and waive, so be it, done, in the conversation. But that's why we support, because ultimately at the end of the day, we do see juveniles do commit some serious crimes. And so there's that tension, and we're trying to find the right balance between those two things.
So I'm concerned specifically because when I think about, again, the Central Park jogger case, there were parents that were there in some instances who knew nothing about the law at all. You know, in one instance, one of the members' family had to go home because she was there so long she needed to get her medicine. And so she left her daughter to advocate for her and for her brother. And you know, when she took over, the worst part about that particular situation in terms of protections is that she was basically told, you know, just go along with the process by the brother, right? Specifically Kevin Richardson. Kevin Richardson said, look, they told me I can go home. If I just say this, I'm just trying to go home. And she said, what are you talking about? You did this? He said, I didn't do this, but just sign the document so that I can get out of here. You know, and the worst part about it is that when it comes to the protections of the most vulnerable individuals, our young people, you know, a lot of times we know that there has been testimony, I think this may be changing, but there's been testimony that NYPD is actually allowed to lie to individuals to get them to pull the confession out of them and things of that nature. But I think the advances that places like Hawaii, California, Maryland, Washington State have done really should be applied. It should be applied to New York, because I don't want a situation where a parent is coming in and saying, we're waiving our rights, or a child is saying, we're waiving our rights, right? I think, and this is a bit of satire, right? The fact that it's kind of in order, you have the right to remain silent. And if you don't remain silent, anything you say can and will be used against you in a court of law. I think that's very telling, right? You have the right to this. You have all of those things. If I waive my rights as a child or as an adult who doesn't truly understand the implications of why I should never waive my rights, all of the things should be protected with an attorney or an advocate who truly understands what's going on, so that we make sure that a person is not convicted, or, you know, as Council Member Holden demonstrated very, very clearly and profoundly, and unfortunately for personal experience, you know, how faulty witness identification is, you know. So I just wanted to kind of put that there and as a statement.
Thank you, Chair. We'll turn to Councilmember Palladino, and then we're going to do a second round of questions if anyone has any additional questions they'd like to ask.
I can't hear you, I'm sorry, you'll have to remove the mask. Can I hear you, please?
No, I'm not going to remove my mask. You could go ahead.
Okay, then, what instructions did you just give me?
I said that you're going to be able to ask questions.
Thank you, that's what, okay, thank you. I couldn't understand you. Good afternoon. I want to thank you all for being here. I especially want to thank Joseph Kenny, the Chief of Detectives for the New York City Police Department, and all of you gentlemen sitting here at the dais, once again, completely and ultimately prepared for what was going to be placed in front of you. And I thank you, because once again, you've come under scrutiny again. The year is 2024, it's not 1980. You've made that very clear. You've come a very long way. Our department has come an extremely long way. We're no longer dealing with paper. We are dealing with electronic filings and everything on a spreadsheet. You guys know your job. Now, my question lies within, you know, what about those that are wrongfully released, that are guilty because we don't have enough evidence? What happens to those people? I also have another question about how we're dealing with the loss of our police department, that you guys have suffered a great loss, a tremendous loss, over 2,000 in the year 2023. I also want to be clear, and I just want to reiterate what Joseph Kennedy has said, Kenny has said. To be clear, even one wrongful conviction is too many. It's a sickening reality when we do find out that someone has been wrongfully convicted. However, I think in the year 2024, we have reduced that by a great number, and if you could supply that with the then and the now in our figures would be helpful to us as well to understand. Are you able to do that?
Can I ask a question as well? The council member said wrongfully released, and I just wanted to get some clarity on what that means. Because I know wrongful convictions is something where a person actually is adjudicated.
There's a lot of people who are brought in that are guilty and are released because there's not enough evidence to hold them due to the discovery laws. So I'm just curious, you know, there have been a great many wrongfully convicted, but there's also been a lot of people who have been released and they are indeed guilty. So I just want to know how.
So
that balances
not that
out.
they've been adjudicated.
I'm asking them.
Oh no, I was asking for clarity because
I just
when I heard the
clarified.
word wrongfully released,
I just clarified.
I was
And they,
I was not.
and let
Yeah,
the
it wasn't
police,
clear.
let's who's sitting in front of us clarify that for me, please.
So let me maybe I can direct this to you all as well, because if this is actually something that happens, that people are wrongfully released, I'm wondering what that means, because something happened and they found out, damn, we got the wrong person. Whereas wrongfully released is kind of a little bit unclear to me because I'm thinking about Khalif Browder as an example. You know, goes to prison, is waiting, years go by, he then is released, and then, you know, a documentary is made for him to really talk about the issues, but he ultimately takes his own life because he couldn't turn the trauma off. I just was, you know, in terms of clarity, is there such things as wrongfully released?
What we see is quite often what will happen during the course of an investigation. We will make an arrest. The police department will feel that we have enough probable cause based on the evidence that we've put together, right? Evidence-based prosecution, along with other things, using technology, using forensics. We will make the arrest. There are instances where we will present the facts of the case to the district attorney's office, who will then maybe perhaps require one or two more things and would decline to prosecute the case or defer the case, and then that person would be released. We work with the district attorney's office on high-profile cases. We usually coordinate with them to decide the threshold of probable cause. We usually don't make an arrest without their assistance or their coordination with us. But in cases where there could be some discovery issues, where a decline to prosecute will be made by the district attorney's office.
Is that all right, Chair?
Yes, absolutely.
And I just wanted to add
Wait,
some.
hold on a minute. Hold on a minute. Hold on. Reset my clock, make sure I'm at the proper time, and no one can talk over me. I won't allow it. This has happened again and again and again. Stop. I have questions here, and I have a police department sitting in front of me that is incredibly credible and prepared for today. So while they are once again undergoing what I consider being cross-examined, you guys have brought us very much up to date. The year is 2024. I don't want to hear about the 1980s. I don't want to hear about 2015. I want to know, present day, how hard yous are working and what you guys are doing to prevent this from ever happening again. And you've laid it out very, very nicely. So if you could please supply me and the panel here with what we have today and what we have in, how many unsolved cases do we have?
For the number of cases, I could just speak for homicides last year. We had a clearance rate of 70% of our homicides in 2023. We had a 47% clearance rate in our non-fatal shootings, which was the highest clearance rate since we've been keeping track of that data. So we are closing our cases with positive results many occasions, more often than not.
Very good. Okay, like I said, thank you very much. I got thrown totally off track here, but that's all right. We know the kind of job you're doing. We appreciate your hard work, and you can't get any more explicit than what you laid out here for us today and what you laid out for the public here today. And I don't think we're going to see very many more wrongfully convicted because of the evidence, is because of the way you pursue it. One thing I would like to say, if we could go back to the lineups and in person, the sooner the better. That certainly does help. And that's all I have to say. Thank you very much.
Thank you. I wanted to just acknowledge also that we've been joined by Council Member Carmen De La Rosa.
Thank you, Councilmember. We're now going to have a second round of questions if any council members want to ask. We're going to first turn to Councilmember Caban, and then if any other members, please make yourself known.
Thank you. I have a lot of questions, so I'm going to try to be brief, and I'm going to ask for y'all to be as direct and concise as possible as well. You testified earlier that you want to get it right, correct? And that you are really good about coordinating with the DA's office, that you don't require them to FOIL information to subpoena, but that you cooperate because you want to get it right, correct?
Well, because we think it's important to have a partnership with them on this important issue, yes.
So you want to be an open book for them, right?
I don't know what that means.
Well, you're saying that you cooperate them because you want to get it right, and so you don't ask them to FOIL or subpoena, but when they ask you for things, you give it to them.
As I understand it, when they ask us for the records, we make sure to provide them with the records, even if it's an old case or a cold case.
So you have a system called Finest. I think it's also called Forms, correct?
Yes, there is a data management system called Finest.
Yes. And so when you have arrest reports and other documents that are put there. There's another data management system that it contains like DD5s and other things. You have a couple of data management systems, but I want to focus on Finest for a second. Okay?
Finest is the trunk of the tree, and all the other ones come
right.
up.
I want to focus on Finest for a second. So you don't allow personnel from the district attorney's offices to have access to view and retrieve documents from that Finest system, correct?
So again, council member,
It's yes or no question.
they do not have direct access.
Okay. And so what's the reason for limiting the DA's ability to view these internal NYPD systems so that they can search the systems and provide complete and timely discovery?
The records management systems, which we maintain where our discovery ultimately lies before it's transferred to the district attorney's offices, are not compartmentalized. So what that means is, yes, there is data and material relating to an arrest that lives on that system, but there's also a vast amount of materials that have no relation to an arrest, therefore are not discoverable under the law, and therefore...
But there are ways to put up firewalls, there are ways to do search functions. You just said that you want this to happen fast, you want prosecutions to be taking place. There's all this talk about how we can't get discovery in time, but you're not letting them in to get this stuff. Does the NYPD ever redact officer disciplinary records or reports before they're provided to the DAs?
Disciplinary records?
Yes.
There are circumstances where law dictates that we redact records prior to disclosing it to an outside party, such as the district attorney's office.
Why?
Certain records must be redacted prior to turning over to a third
Why?
party. There's civil rights law, there's
Explain it, why?
family court law.
Why? What is the basis for doing that when that disciplinary record tied to that officer who is likely the arresting officer who likely generates the DD5s and all of the evidence that then gets handed over to the DA that they rely on for everything from an indictment to a bail request to a trial, right, to prove a case beyond a reasonable doubt where a person's liberty is at stake? Why?
Council member, I'm hearing you, however...
Because that case gets thrown out. Let me give you a scenario, right? In my almost decade of practice as a public defense attorney, I had a situation where I had a client. The client, we got what we thought was all the discovery. A year later, this person lost their housing, they lost their kids. They were losing everything. We get to trial, it's time to do the suppression hearings, and the DA hands over disciplinary records of the officer that were held back by the NYPD, and the judge calls us up and says, get rid of this case, there's no way you can put this cop on the stand, the damage has been done. Why is it that the NYPD reacts to disciplinary reports before they're provided to the DA? Why isn't that given from jump when an adjudication begins?
So that's an unfortunate scenario, and
Oh, it's a regular scenario, but I want to know why. I don't want to know that it's unfortunate or whatever. I want to know why.
NYPD's priority is to be compliant with the law.
I thought it was to get it right.
It's both.
Those things often go hand in hand, and council member, just one other thing. Let's just be very clear. You were a public defender.
you answered
Wait, you understand the difference between redacting and then not providing. In the scenario you gave...
Timing is everything, and so I want to know why it's redacted from the beginning, why it's not handed over, why it's not transparent from the beginning.
So you started
And I
with...
got my answer, so I'm going to move on, because I only have 45 seconds left. Another question I want to ask is something that the chair mentioned. Different policies that other places have taken up. So there's a policy that was just enacted in Seattle which would prohibit and require approval for officers from knowingly making false statements and ruses, essentially not allowing officers to lie to people to elicit confessions or whatever it might be. Would you consider adopting a similar policy here in New York City?
We're always willing to engage and talk about anything in regards to what we think would make better investigative techniques and create better products, convictions, arrest packages. And ultimately, at the end of the day, we want to make sure that what we're doing is lawful, which you can see throughout all of our procedures.
Chair, may I ask just one additional question? Does your lab still, and I'm jumping around a little bit, but does your lab still do bite mark analysis testing?
No, we do not. No, number one, that's the function of the chief medical examiner. A medical doctor would review a bite mark forensic odontologist.
Okay. I just want to conclude by saying and providing for the record that you all also testified in response to one of my colleagues' questions about DNA evidence and how the science is excellent. Another frustration I've had as a litigator, as a criminal defense attorney, is that the scientific community is ignored over and over and over again when it comes to scientific evidence or forensic evidence that is admitted in court. They weigh in, it gets ignored, and as a matter of science, at least half of all wrongful convictions that relied on DNA testing are attributable to the misuse of forensic sciences during the investigation and the trial. Bite mark analysis, which I'm glad isn't being used before, but even the way that latent prints are being used, a lot of it is junk science. It's accepted as valid evidence in criminal cases, allowing experts to come in, but it isn't accepted by the larger scientific community. And so I think that's something that the NYPD needs to be much more responsible around before taking in that information, giving it to the DAs, and then selling it in a courtroom to a jury as though it is the gold standard when it absolutely is not.
Is that a question or just a statement? That is a statement. Okay.
I just want to ask one question. We're talking about exonerated, vacated, wrongful conviction. Can you just clarify the differences between those three?
So, I'm sorry, exonerated, wrongful conviction, and I'm sorry, what else?
Exonerated, vacated, and wrongful convictions.
So, vacated is the official mechanism by which the court dismisses of the case from the record. A wrongful conviction is a term of art that I think means a lot of different things to a lot of people. I don't think that you can't go to like Black's Law Dictionary and say this is what a wrongful conviction means. But a wrongful conviction could mean a lot of things. Specifically, we no longer have credibility and faith in the case that was initially done due to a bunch of reasons. Either new evidence came up, a witness recanted, because by the way, for the record, often, I'm not going to say often because I don't have the numbers, but it is possible that there's a wrongful conviction through no misconduct of NYPD. I hate that does happen, right? You can have witnesses that make mistakes, like that does happen. But long story short, it's the DA has lost faith or there was contrary evidence that was presented, so as a result, within the conviction itself was improper, wrongful conviction. Exonerated, I don't know, these things kind of Venn diagram a little bit, but exonerated basically means we have good faith that you didn't do it, that it didn't happen, right? There's a difference between we don't have faith in the evidence and we affirmatively don't think you did it, right? And does anybody else want to weigh in on that? See if I got it. I think that's a layperson's way of describing that because it's not like they're literally defined, I hope at least.
I appreciate that, and I appreciate the fact that the one thing I wanted to really extrapolate was that it's not always on the NYPD. Right. It could be on the DA, it could be on the witness, it could be on anybody who came in. So it's not always on the NYPD. And the NYPD always, or maybe most times, works with the district attorney's office when these cases do come up for exoneration, vacation, or being vacated or wrongful conviction, and are standing beside the DAs when those announcements are made. So it is not the intention of the NYPD to arrest and convict the wrong person, because as the chair has stated, as my colleagues have stated, because that leaves the person who committed the crime on the street, and that's not what you do. It is your job to put away bad actors, and we appreciate you for doing that. And we're sorry that you were attacked at some points today, but I'm so proud that you had all the answers, the right answers. And I'm so glad to see how far the NYPD has come to make sure that these types of incidences do not happen at such a frequency anymore. Thank you.
I got to tell you, I'm definitely very, very inspired by the work that the NYPD is describing today. You know, it offers us a way forward that perhaps in the past would not be possible. I'm wondering though, and I'm thinking about some of the recommendations that have been passed down from the National Commission on Forensic Science, you know, they recommended that the DOJ labs post their policies, procedures, and all 3 Department of Justice crime laboratories, the DEA, the ATF, the FBI, have subsequently published their quality management systems online. And I was wondering if the NYPD is willing to do so.
Well, we already turned over our SOPs, our standard operating procedures, our quality management procedures. We turned that over to the district attorney's offices. It's part of discovery. So if I needed to find that information on a case or anything like that, the actual procedures, they can get it. We turned that over as part of discovery. It's readily available. Similarly, with respect to reviews of our forensic evidence, we are accredited labs. Our labs, our NYPD lab is an accredited lab. We work with hand in hand with ANAB, our accrediting body that certifies our main lab, as well as our latent print section, as well as our crime scene unit. We are accredited. We report to the New York State Forensic Commission. They review our work, and that's public record. So if there was a criticism of a science, such as latent prints, or for that matter, any other procedure the NYPD uses, it gets reviewed, and parts and parcel are their standard operating procedures. They're readily available pursuant to discovery.
Well, the reason why I'm asking that specifically is I know that we spoke earlier and heard testimony that it's actually turned over, but I'm thinking about the difference between that and actually having that published online itself.
I definitely think that's something we can take into consideration and possibly recommend it and consider that. If we're able to do that in terms of technology, then it's something we'll definitely consider.
I think it'd be really, really helpful, especially because we're as been said by our mayor, we're the greatest city in the world. We have the greatest police department in the world, and to make sure that we really keep those same high standards. I'm thinking about myself as it related to the criminal justice system, and in the past I was told that I was going to be seen as being innocent until proven guilty. And the worst part about my case, although this wasn't the fault, as has been described as other council members, of the police department themselves, but it was a, so to speak, trifecta of what the police department investigated, what the media reported, and then ultimately what the DA began to prosecute. And I gotta tell you, the most hate, and I'm gonna use that word specifically, it was vitriol, that I particularly experienced was not from the department, the police department, but it was from the media then, and most certainly from the DA's office as they prosecuted us. And so I applaud the efforts that we are trying to make sure that we get it right, that we fix things that could be problematic, so that folks don't go to prison for crimes that they didn't commit. And as we look at all of the testimony and recommendations, I think one of the best things that I've heard today, although I know we are not necessarily there yet, is that we're relying on a lot of the technological advances to move the needle. And I think about that because we really need to make sure in 2024 and beyond that we make the process easier. Easier for you all because there's so much work that needs to be done. We don't want folks to be committing crime, but easier also to make sure that the integrity of the systems that we are representing are there. So I want to say thank you. Thank you for being here today, for staying. Thank you for this part of the program. We are going to close this part, and then we're going to open it up to the public as well. We hope that you all stick around to listen to what the public has to say, and thank you.
Thank you for your time, everybody.
Thank you.
Thank you.
Thank you. So we will now turn to the public testimony. We will only be allowing testimony that is on the topic. Thank you. I'm passing this back to Sir.
Thank you so much, Chair. So we're going to begin public testimony. If you want to testify, please sign up at the back of the room with the Sergeant at Arms. First, we're going to hear from Sergio De Pava from the New York County Defender Service. Okay. First, we're going to hear from Sergio De Pava from the New York County Defender Service, followed by Bruce Bryan. So if you two want to come up to this podium, and then we're going to just continue calling folks from there. He's not coming. Okay. Bruce Bryan, followed by Jackie Gostijan, Sarah Chu, Cassandra Kelly. No, they don't. But I think that if anyone was that's all. Yeah, why is she so rude and disrespectful? Like that's beyond the pale. I understand that, but like. For folks who are up here, just whatever order, I guess.
I guess ladies first.
Ladies first. Whoever wants to go first, or we're all going to get a chance.
You want me to start? All right. Are we still morning? Okay. Officially afternoon. Good afternoon. My name is Jackie Gustigian. I am Supervising Policy Counsel with Brooklyn Defender Services. I've been a public defender for over 15 years, and I want to thank the council and Chair Salam. It's an honor to be before you, and we look forward to working with you and the rest of the council. As public defenders, we see every day how the NYPD's practices do not appropriately protect New Yorkers from wrongful conviction. In our written testimony, we highlight many concerns about NYPD policies as they relate to evidence, forensic science, interrogation, racial profiling. However, in my limited time, I will highlight a few key points. Timely access to discovery is critical in preventing wrongful convictions. Much of the information for discovery comes from law enforcement, and New York enacted comprehensive discovery reforms in 2019. However, even though NYPD has spent millions of dollars on document and case management systems, data collection and storage products, and partnered with companies like Microsoft and IBM to build systems to share collected data, including police reports, body-worn camera, videos, and other digitally collected evidence, turnover discovery continues to be inexcusably delayed. You heard NYPD say that everything is electronic and that DAs have access, but then when questioned further by Councilmember Caban, they admitted that in fact DAs do not have direct access to their finest system. It's simply not true. I want to point to a recent court decision from the Bronx in September of last year. The court in that case characterized NYPD's refusal to turn over discovery to DAs as akin to NYPD holding discovery as ransom, and the judge said that that NYPD is requiring DAs to, quote, jump through a series of NYPD-crafted hoops to receive discovery. That is what's really going on. NYPD's data systems are designed to make the collection and sharing of information quick, straightforward, and simple, and yet NYPD's fundamental lack of transparency and failure to turn over to their records to the district attorneys continues to prevent someone accused of a crime from seeing their evidence. We call on the City Council to investigate NYPD's lack of transparency and delays in providing access to records, documents, data, and video content. And I'll sum up after this last point. Errors in forensic analysis are one of the leading factors in wrongful convictions. You heard Councilmember Caban talk about the latent print scandal from 2015. Additionally, there was a serious scandal involving OCME, where a supervisor conducted the analysis for 2 junior analysts on a large number of DNA cases. He did the actual work and then signed off for the junior analysts, setting this up for a process where everyone involved would have in fact been perjuring themselves. We call on the council to demand a full-scale audit of the latent fingerprint lab and of the OCME. Similarly, in Houston and DC, this full-scale independent investigation was done. We believe that it's time for New York to do something similar. And I'll end by just saying that we look forward to the opportunity to continue to work with the council to prevent wrongful convictions, to ensure that those wrapped up in the criminal legal system have free access to zealous representation, and to invest in our communities instead of police them. Thank you very much.
Thank you for your testimony.
Hi, good afternoon. My name is Cassandra Kelly, and I've worked as a public defender for over a decade. I'm currently a policy attorney with the criminal defense practice at the Legal Aid Society. On behalf of the Legal Aid Society, thank you for the opportunity to testify today about our concerns with NYPD practices and policies that increase the risk of wrongful convictions. We've submitted written testimony that goes into greater detail about our concerns and our proposed solutions to address them, but I'll briefly address them here. Every case we take on in our criminal and juvenile practices at the Legal Aid Society begins with a police encounter with a fellow New Yorker. That initial encounter and the ensuing arrest, investigation, plea offers, hearings, and trial stem from the first moment an officer approaches a neighbor, a father, a mother, a son, a daughter, and a colleague and a friend. Too often, police are acting as first responders in situations that stem from a moment arising from a mental health crisis or from drug use or simply lack of safe shelter. Too often, the police are using their widespread and robustly funded surveillance technology to sweep our young people into their precincts for interrogation and at the threat of arrest. Too often, it is officer misconduct and abuse that results in the apprehension and prosecution of innocent New Yorkers. And too often, once this person has been arrested and charged, the police do not share all the evidence they collect during the investigation process with prosecutors, which impedes defense attorneys from conducting a thorough investigation and evaluating the charges levied. Despite the billions of dollars allocated each year to the NYPD, despite the ubiquitous surveillance and technology that is touted by the NYPD, prosecutors claim that they are unable to expeditiously obtain discovery on criminal cases because of their inability to obtain it from NYPD. Meanwhile, when it serves the interests of the NYPD, these same hard-to-get materials, body-worn camera footage, surveillance video, images of evidence will be posted on NYPD's social media feeds or released to the press almost immediately. In case after case at the Legal Aid Society, we don't receive basic pieces of evidence like memo books, witness statements, body-worn cameras, 911 calls, and police disciplinary records for months and sometimes years after an arrest. We cross-examine officers and expose their lies in court, but see no disciplinary outcomes. As public defenders, we have long recognized the problem of unchecked police power and see how it devastates whole communities, disrupting and destroying lives. We know another way is possible. We must force reform to rein in the misconduct that too often leads to wrongful convictions. Thank you for your time.
Thank you for your testimony.
Hi, Chair Salam, council members. Thank you so much for holding this hearing and for the opportunity to testify today. My name is Dr. Sarah Chu. I'm the Director of Policy and Reform at the Perlmutter Center for Legal Justice at Cardozo Law School. Prior to my current position, I spent 15 years building the Forensic Science Policy program at the Innocence Project. And Chair Salam, we have been deeply enriched by your leadership on the board there. So I wanted to take my time in the oral testimony to offer some ideas in response to what Mr. Fenton said about NYPD's response to forensic science issues. As Chair Salam aptly pointed out, that posting quality management documents, your policies and procedures for forensic testing, it's something that the